Right, Mr. Justice Cooke here. Is everybody ready to start?
Yes, I am. It's Mr. Lovett here.
Yes, thank you very much. And you've got Mr. Jury with you, I understand.
Remotely, I have Mr. Jury with me, Your Honour, yes.
Yes, well, remote. It's all very remote, yes. Mate, do you need to make the usual notice about the form of the hearing and so on?
Sorry, Your Honour, was that a question directed at the clerk?
Yes, normally the associate says things about this hearing taking place remotely and so on and so forth, but I don't know if they want to make that announcement or whether we just carry on. Is the associate there?
It sounds, Your Honour, perhaps we should just carry on.
Well, I saw a note a moment ago saying the recording had started, so I guess that's okay. So, Mr. Lovett, you can take it that I've read the papers. I will have a few questions to ask, but you take it in the order you want to take it.
Thank you, Your Honour. What I thought I might do, both applications clearly relate to the same factual matrix.
Yes.
Although they are different to a substantial degree, and what I'd like to do is just take you briefly through the evidence, if I may, of some of the more substantive breaches. I don't want to take you through everything because everything has been, or most of the breaches that have so far been uncovered are set out in quite some detail in the evidence of Mr. Bortman and Mr. Aziz. And I apologise for the volume of papers that have been delivered to you, and we tried to keep duplication to a minimum, but I'm afraid inevitably there is some overlap between the evidence in relation to the two cases. But if I could start with one amendment which I'd like to make for the record, which is that the application notice in the director's claim, which is the claim against the four defendants, says that the particulars of claim have been served on IH and Mr. Rame, and that is not correct. In fact, the claim forms have only been served on the parties in each case. It's a relatively minor error, but nevertheless, it's one that's been picked up and one that I wanted just to amend for the record.
Sorry, I haven't got that. The claim form as opposed to the particulars of claim.
Correct. So it's just the claim forms that have been served on Mr. Rame and IH, but the particulars of claim have not been served.
Yeah. Okay.
And Mr. Rame has been Sorry, Your Honour.
I was going to say, does that make a difference in terms of the rules as to the requirement for permission to amend?
No, I don't believe it does, Your Honour.
Okay.
Oh, sorry. Mr. Jury has told me that actually the points of the particulars of claim have actually been served on IH. It's just that the claim forms only have been served on Mr. Rame.
Got it. Yeah.
And in relation to the amendment, Your Honour, you would have picked up that we're only seeking permission to amend in relation to the claim against the directors. No permission is sought against Mr. Rame, and as I will come on to explain, there is a reason behind that. In an ideal world, we would have sought to update Mr. Rame's the particulars of claim in Mr. Rame's case as well. But
I was going to ask about that. I mean, I have a problem at the end of the day, which you'll need to grapple with, which is the question of particulars of loss and how that works. I mean, I think in all likelihood, you will need to particularize the losses that are claimed in each action and the causation of those losses. that doesn't mean that one can't deal with the points of principle that arise today. But I have a bit of a problem because of the need to distinguish at the end of the day between what is truly double derivative action and reflective loss that is actually suffered by COREC, direct loss by COREC, which is reflective loss for international holdings. And whilst I can see the Article 54 argument, some of the other stuff doesn't fit quite so neatly into that. And therefore there may be a need to spell the whole thing out in the pleadings so that if and when an issue arises in relation to it, one can identify quite specifically how the claim works in relation to different aspects of loss. And of course, that does bring into sharp focus the question of any additional losses that you want to claim against Mr. Rami.
Yes, indeed, and perhaps Your Honour, if I could address you on this, on the question of reflective losses, after I've just summarised the evidence, and then it kind of puts that perhaps into a little bit more perspective. But I take the point about spelling out the breaches and the causation in both claims, but. The reason that and I'll deal with your question now, the reason that Mr. Rame's claim form hasn't been amended is that there is, as you will appreciate, a potential timing problem with service of proceedings against defendants who are, at least two of them, who are based in Iraq.
Yes, sir.
Which invokes the provisions of the Riyadh Convention, which do not apply to the claims against Mr. Rame. Of course, in the director's claim, we will have to wait until all the directors are served, to the extent that they have to be served pursuant to the Riyadh Convention. But in Mr. Rame's case, and particularly in relation to the claim which is made against him solely, service has already been effected against him in Lebanon, because Lebanon is not a party to the Riyadh Convention. And it was partly for that reason that the claims were separated out in that way, because we anticipated, having been involved in other cases, that there would be a good degree of time taken up, particularly with recalcitrant defendants who do not want to be served in accordance with the Riyadh Convention. We figured it might be better just to split them out and try and accelerate at least one of the proceedings if, in Mr. Rame's case, he could be served.
Understood. I'm familiar with trying to serve in the KRG and Iraq under the Riyadh Convention. It's a point that's come up in previous cases.
Yes, indeed, Your Honour. And of course, we're very familiar with the Pearl Petroleum case and the issues that came up in that as well. So perhaps I don't need to address you too much further on that. But the other point of difference is, of course, between the Rame claim and the claim against the directors, is that the directors' claim is by and large a claim of omission, whereas the claim against Mr. Rame is a clear claim for self-dealing, breach of fiduciary duties, and so forth, i.e. sort of more of a commission type of a complaint. But if I could just leave that aside, if I could just park the question of reflective loss for a moment, and I will come back to it.
Can I just make
Yeah.
sure, Mr. Lovett, you grasp the problem that I have? I'll spell it out as I see it. As I read Article 54, a shareholder in a company is entitled to take action in relation to self-dealing by a director with a subsidiary. I'm using your expression of self-dealing because as shorthand, but you know what I mean by that.
Yes.
But where the claim is made, not in respect of that director's self-dealing, but in respect of his failure as a director to do something about another director's self-dealing, or to pursue actions of one kind or another, and the loss is truly felt by the ultimate subsidiary Cooke, how does that then work? And there may, as I say, be a distinction between the different types of claim. It's not just a claim being made on behalf of international holdings, which of course is the whole purpose of your seeking permission to bring a derivative action. Yes. It's what's commonly referred to as a double derivative action, because it's on the part, essentially, when I say on the part of, it's in respect of the losses that are incurred by the subsidiary further down the line.
Yes, indeed, and I will address you on those. But if I could just lay a marker, and it might be helpful for the purpose of the evidential review.
Yes.
There are losses that have been suffered directly by IH. I mean, even if one was not persuaded, or even if you are not persuaded that there is an exception to the reflective loss principle, there are some claims that are recoverable directly by IH.
The subscription agreement claim. The subscription agreement claim is one of those that's direct, isn't it?
Yes, indeed. That's one, and that's been the subject of arbitration proceedings. And again, I'd like to address you briefly on that, because there has been a development since I think the application has been put together. But essentially, that arbitration, the subscription agreement arbitration, has been concluded, and that is potentially one source of claim which IH has directly against the directors for failing to act. And the other one, of course, is the claim in relation to the loss of the shareholding, which is the loss of IH's only asset.
Yeah.
And the claim essentially is that, the claims essentially against the directors is that they have frustrated attempts by IH to seek to sort of steady the ship and to protect its only asset, which are its shares in Cooke. And of course, we recognise that there may be arguments that are raised in relation to causation in connection with that particular loss, i.e. the loss of IH's shares. But in my submission, if I may, I'll come on to expand upon that. But in my submission, provided we have a prima facie case as representatives of IH against those directors for failing to do anything to stop the transfer of those shares out of IH, then that ought to be enough for today's application, for the permission application. And I'm not sure that today is the right occasion to delve into the detail of the causation arguments, although I can certainly go through them and take you through them later in my submissions. But those would probably be the two main claims that IH has directly in relation to the losses occasioned to Cooke.
Understood. You take it as you wish. I'm not clear in my own mind, but maybe you can show me. And this is the point I was asking about at the outset. I'm not clear that you have spelt out what the loss actually is in relation to the shares and so on. I mean, I know I'm teaching grandmother to suck eggs, Mr. Lovett, and you've been in this business for a long time. But ordinarily, when one pleads a case, you plead, duty, breach, and damage, and you plead particulars of loss and causation. And I don't think you've done that. You're well aware of the causation issues, obviously, which arise in relation to the CMC decision, and so on and so forth. But I think those are going to have to be spelled out, because they are matters that the court's going to have to grapple with. And if the case is defended, then one's likely to have interlocutory applications that grapple with those issues, and therefore the pleas become all important. Anyway, I will keep my mouth shut for a bit, Mr. Lovett, and you take it the way you want to take it.
Your Honour, that is incredibly helpful, and I have to say, and you probably got this from my previous submission in relation to any potential further amendments to the claim against Mr. Rame. But one of the issues that you've identified is that perhaps the claim against him, as it currently stands at least, would not be contested. And therefore, we would have to be in the position of persuading a judge to accept our assessment of loss and damage. And in the course of that assessment, no doubt, we would then have to particularise the loss and damage and the causative points. But if I could just take you back to the claim against Mr. Rame first. And then just look very briefly at some of the evidence. I don't want to take too much of your time, given that you've read the skeleton and the evidence of Mr. Bortman and Mr. Aziz, but it is quite key to the application, and I think I ought to do that.
Very good.
So if I could just take you, and I'm really focusing on the Rame claim, so CFI 2019. So if I could ask you to take that skeleton. The first part of the skeleton is effectively an introduction to the investment and the money that was invested by the shareholders. Here we have, of course, Agility, which is a Kuwaiti company, and Orange Telecom, who between them invested approximately $810 million into Corec. And as a result of that investment, as one would ordinarily expect, in terms of trying to achieve checks and balances, the parties entered into, not only did they enter into a series of funding arrangements, which are not particularly material for the purpose of this application, but what is material for the purpose of this application is the shareholders agreement that they entered into. And it's relevant because under the governance structure which the parties agreed to, International Holdings, which was the DIC company which is incorporated to hold the shares in Corec, to hold at least the Orange and Agility shares in Corec, as well as the CS shareholder shares, was subject to a regime of governance whereby the CS directors, and the CS directors are the Iraqi directors who derive from the original investors or the original owners of Corec. So the CS investors were to appoint 3 nominees to the board of IH, and the joint venture company Iraq Telecom was to appoint a further 3 directors, and then there was to be an independent director who was Mr. Rame, who it turned out, unbeknownst to the joint venture parties at the time, but it turned out that he was a very close affiliate of Mr. Barzani, but not only was he a close affiliate, he was very unindependent, far from independent, I think is the expression that I use in the skeleton. And it quickly became apparent that having a majority on the board, the original owners or the original shareholders in CS and in Corec Telecom, together with the so-called independent director, Mr. Rame, were able to control very substantially not only the activities or inactivities of IH, but also the activities of Corec. As things were originally envisaged, Mr. Barzani was appointed as the statutory manager of Corec. And under Iraqi company law, Corec does not have a board of directors, and Mr. Barzani is the sole manager, the statutory manager of Corec. So effectively, he has day-to-day control over Corec. But once again, there were intended to be some checks and balances on that power. by the creation of what was called the COREC Supervisory Committee, which was made up of the same members as the board of IH. And the purpose of the Supervisory Committee was essentially to keep Mr. Barzani in check and stop him from doing whatever it was that he wanted during his...
Mr. Lovett, I haven't quite grasped how the Constitution works in terms of the Supervisory Committee and the statutory manager. I mean, it obviously isn't a board of directors, but it has some sort of function, obviously from its very name. But how was it intended to work?
Well, I could take you to. I'll have to get the reference, but I could take you through to the relevant provision. I think of the shareholders' agreement. It was a creature that was created under the SHA, under the shareholders' agreement.
Yeah.
And it was literally, as you say, it was akin to a supervisory board, but I think it had an informal function. It wasn't a formal creature under Iraq law, because Mr. Barzani solely had control of COREC as the statutory manager. But it was an attempt under the shareholders' agreement to inject some sort of formal supervision to the activities of COREC on a day-to-day basis. And although the members of the COREC Supervisory Committee were the same as the appointed nominees of IH, their function as members of the COREC Supervisory Committee was slightly different. And I think I'll ask one of my associates for the reference, but the functions of the COREC Supervisory Committee were set out in the shareholders' agreement.
Very good.
And IH, one of the functions of the IH board was to appoint a statutory manager, and it was agreed again in the shareholders' agreement that Mr. Barzani would be the statutory manager of COREC. But to all intents and purposes, it's the statutory manager in COREC who wields the power. The COREC Supervisory Committee, as I say, it's effectively a sort of shadow form of management, but it doesn't have any formal recognition under Iraqi law.
Right.
I'd like to address it. So the investment is set out in the first part of the skeleton, from paragraphs 2.1.10 to 2.1.14. And then I would like, just before I turn to the specific complaints that are made against Mr. Barzani and Mr. Rame, and then by necessary inference against the directors in relation to the directors' claim, if I could take you in terms of the chronology to the CMC decision, which was the start of the rot, if I could put it that way. Because, and this is at paragraph 2.1.16 of the director's skeleton on page 6.
Yes.
So the CMC is the Communications and Media Commission. It's the regulator of the Iraqi telecoms industry. And having made this investment in 2011, in July 2014, the CMC decided and ordered that the claimant's investment in COREC was null and void and of no effect. And it effectively, it was almost like a restitution. It ordered that the position of the parties should be put back as they were on the 13th of March 2011, where all necessary actions to ensure the cancellation, revocation of the transfer of share capital in COREC were to be made. And that was that has become known as the CMC decision. Now, we call that the CMC decision was not implemented at all at the time. And in fact, it was not implemented at all until around April 2019, when the herbal company's registrar, we would say, took it upon himself, but that may be a point of dispute, but we would say took it upon himself to partially implement the CMC decision by re-registering IH's shareholding into the names of the original Iraqi shareholders. And we call that, that's referred to as the administrative decision. And as you can imagine, Your Honour, there's a raft of claims that have followed from that, and they're not, I might refer to them in due course during the course of submission, but as you can imagine, the decision to remove the shares, or at least purport to remove the shareholding from IH, has given rise to multiple claims, both in arbitration and litigation.
Can I ask a question? Can I ask a question,
yes.
Mr. Lovett? Cooke is an Iraqi company. The CMC, I take it, has some statutory authority within Iraq.
Yes.
What I'm really asking is prima facie, and I know there are allegations of corruption in relation to the CMC decision, and possibly in relation to the herbal company's registry decision too. But as a matter of Iraqi law, as matters currently stand, who is technically the shareholder in Cooke?
Well, as a matter of Iraqi law, I think we would have to concede at least the legal title in the shares vests in those shareholders, the original shareholders, including 75% as to Mr. Barzani's ownership.
Because the CMC does have authority to do what it did, whether it did so corruptly or not.
Yes, indeed, and it's a combination of the CMC, but it was the registrar of companies in Erbil that we say partly implemented the CMC decision, because of course, yes.
You shouldn't have one without the other. I fully understand.
Yes, exactly. It was, I don't need to address you any more on that, but you're absolutely right, Your Honour. I think initially we it took a while, because this came as quite a surprise, nothing having been done for a number of years, and we received notification, or the client received notification of this register of transfer in shares, and as one may imagine, it was quite difficult to get to the bottom of things. But I think as things currently stand, our position is that it would appear that the shares have in fact been re-registered. So as a matter of domestic Iraqi law, yes, those shareholdings are now back with the original shareholders. But of course, it leaves questions open, A, in relation to claims that arose prior to that taking place, and B, whether or not there is a concept of a constructive trust or some other form of arrangement whereby IH can assert some sort of beneficial interest in those shares, even though the legal title has passed to others.
Yes, and I suppose, self-evidently, if there's corruption and so on, then the other questions which arise is the extent to which anything so ordered has any effect in relation to agreements that are governed by a different law, and fora of one kind or another, whether arbitrations or the DIFC court, and its recognition of what's taken place.
Yes, indeed. Yes, indeed. I mean, there are a number of legal issues that flow from this and flow from the alleged corrupt activity and the decision that we say was procured by corruption. But I think for the purposes of today's application, we would say that the door is still open to claims, particularly by IH, that arise out of the what we would determine as the misappropriation of its shares.
Yes.
So that really then takes me on to the evidence, and if I could take you to, I was going to take you to the evidence of corruption, but I think if Your Honour, you're familiar with that and familiar with Mr. Bortman's evidence, and the evidence of corruption is, we would say, quite cogent. It comes from more than one independent witness, and although there are criticisms that have previously been levelled at Mr. Bortman's evidence, you can see from his witness statement that the allegations he makes are extremely serious, but they do derive from a number of different sources, both from within the CMC itself and from within Corec.
Yes, I mean, on the face of it, there's a prima facie case of bribery and money changing hands and expensive watches and so on and so forth. Yeah, no, I've got that.
Yes, indeed. Well, in that case, Your Honour, thank you. I won't take you to that. But if I could then take you on to the, if I may say, the nub of the claims in the director's case, and some of the behaviour that's the subject of the complaints that's made against the directors. And you've already clearly identified that the complaint against the directors in this case is their lack of activity in prosecuting or at least even investigating claims against Mr. Barzani, distinct from those claims which are made against Mr. Rame, which are actual breaches of fiduciary duty. Although there is one allegation of an actual breach against one of the other directors, which is against Mr. Aqrawi, which is an allegation that he owns an interest in a company which appears to be doing business with Corec, and I will come on briefly to that. But in relation to the director's claims, as I said earlier, I don't intend to take you through each and every detail of the claims, and I'll try and restrict my focus to some of the more egregious claims. But if I could take you to the witness statement of Mr. Aziz, please.
Yeah.
So that's bundle E. It's probably easier if you do it with by reference to the tab numbers. It's bundle E. It's tab number 9.
Yes, I've got it.
Thank you. And then if I could start, so Mr. Aziz gives some evidence of the financial arrangements leading to the incorporation of IH and the way in which the shareholding worked and so on. And then he summarises some of the claims against the directors at the front of his statement. But the nub of what he says starts at paragraph 38.
Yeah.
And that the heading of that, for the record, is breaches of duty on the part of Mr. Barzani as the statutory manager of Corec and director of the company. And then Mr. Aziz says that he describes Mr. Barzani's multiple breaches of his duties as statutory manager of Corec and as director of the company. Because Mr. Barzani, of course, is also a director of IH. And the reason he's not a defendant to these claims is purely and simply because he is individually a party to the shareholder agreement, which has an arbitration clause. So a number of claims that are being made against Mr. Barzani have been replicated in a separate arbitration, which is ongoing pursuant to the shareholders agreement. Now, the first complaint which Mr. Aziz makes is in relation to the IBL loan. And again, I should let you know that there is there is an arbitration, an ongoing arbitration in relation to the IBL loan, in which an application is being made to set aside a subordination agreement, which IBL is a Lebanese bank, and IBL agreed to loan money to Corec in exchange for a personal guarantee from Mr. Barzani, and also in exchange for payments of significant amount of interest. But also, crucially, IBL Bank wanted certain shareholder loans to be, or a shareholder loan to be subordinated to the interests of IBL Bank. In other words, IBL would take in priority on any interest payments and any repayment of capital.
Well, there are 2 points. Aren't there 2 points that arise here, Mr. Lovett? One is the misrepresentation claim, which may give rise to the setting aside of the subordination agreement, i.e. the representation that it wasn't secured, apart from the guarantee. And secondly, the self-dealing aspect, in as much as Mr. Barzani gets a huge whack of interest, which you say is much more than it would have been had this been a conventional ordinary loan. It all comes back to him on his collateral, his deposit that he's put with IBL Bank. But as I understand it, both of those matters are part of the arbitration between...
Well, yes, Your Honour, you're absolutely right. They are part of the arbitration. Although it's really the setting aside those gains will be part of the shareholder arbitration. Yep. There's a separate arbitration which IBL is a party, which seeks to set aside the subordination agreement on the same factual basis that the subordination agreement was procured by fraud. But as part of that arbitration, there is also a claim for damages. But that claim for damages may, it's not entirely clear at the moment, but that claim for damages may itself not be able to be dealt with by the current arbitral tribunal. And that's a matter that's currently under discussion. But there is another arbitration agreement in the loan between IH and Corec. And so there are multiple agreements relating to this IBL loan and the subordinated loan, which are subject to arbitration agreements. But cutting through these arbitration agreements, the submission that I would make in relation to the misfeasance or the omissions of the directors in this case is that they were perfectly, or ought to have been, aware of the issues in relation to the IBL loan, and certainly they were put on notice of those issues in November 2017. But the directors themselves have done nothing to try and address this. And of course, as time goes on and Corec becomes in a more parlous financial condition, and IH is saddled with the subordination agreement. Now, whether that agreement is set aside is a matter for arbitration. But if it is set aside, and in my submission we're confident that it should be set aside, or it would be set aside, because it was procured by fraud, then the directors have in my submission, they have a case to answer. Because of course, if they'd have grappled with this problem sooner, and they'd have done something about it in the name of IH, and they'd have taken action to try and annul the subordination agreement, and then recover sums that may have been due to IH under the IH Corec loan, then they could have undertaken something that was of benefit to IH. So this is one of those claims that has a direct IH benefit and is not reflective of Corec's loss.
Correct. Yeah, understood.
So really, that's the IBL. Clearly, Your Honour, I won't take you in any more detail then through Mr. Aziz's evidence on IBL, because you have the point that there are two claims, and we say that had the directors been more alive to this, and not only more alive but more willing to do something about it, then there's a very good chance, subject to issues, of course, of causation and so on, and Correc's ability to pay the money back. But there's a very good chance if they'd taken steps earlier, IH would have been in a better financial position.
Yes.
If I could move on then to paragraphs, and just to be clear in relation to, before I leave the IBL loan, the IBL loan is an allegation that also involves Mr. Rame, as well as one of the underlying complaints against Mr. Barzani that the directors ought to have done something about. The allegations in relation to IBL are that Mr. Rame was in the thick of it as well, because he made certain representations to one of the Orange board members when he asked about the collateralization of the loan. But I ought to make that point, because that's clearly a claim that can be laid at Mr. Rame's door, as well as the directors in a different capacity. Mr. Aziz then goes on to talk about the competition, Mr. Barzani engaging in competition with Corec, and that's at paragraph 59 of his witness statement.
Yes.
And so one of the complaints that's made against him is that in the shareholders' agreement, Mr. Barzani agreed to restrict his activities that were in competition with IH and Corec, and in particular in relation to his involvement with a company called Iraqcell. And the allegations are set out, or the background to the allegations set out in Mr. Aziz's witness statement. And one of his undertakings, which is contained at paragraph 60B of Mr. Aziz's statement, is that unless otherwise agreed in writing by Iraq Telecom, Mr. Barzani would use all reasonable endeavours to liquidate or dissolve Iraqcell as soon as reasonably practicable following the date of the Iraqcell agreement. And then Mr. Aziz goes on to say that Iraqcell has not been liquidated nor dissolved, and contrary to the undertakings made in the Iraqcell agreement, Mr. Barzani continues to hold an 80% equity interest in and serves as a director of Iraqcell. And then Mr. Aziz goes on to say that it was recently reported that Iraqcell is working on a fibre optic cable network, and it's installing 1,500 kilometres of fibre optic cables, and then there's a project pipeline that involves a further 4,000 kilometres. So a very significant, we would say, a very significant breach of that undertaking, and a very significant competitive activity. So that relates to Iraqcell. Also briefly, if I could just take you to another part of Mr. Aziz's statement. So if we could go to paragraph 68.
Yeah.
So this is engaging in undisclosed self-dealing with Corec suppliers. One of those is the Darren Group, and the reason I single out Darren Group for particular mention is that the number of orders during the period 2011 to 2016, the amount of money and purchase orders that have been issued by Darren Group, or the amount of money that it appears to have been paid by Corec, exceeds $219 million, which is almost a quarter of the total investment by the joint venture parties. So a very significant diversion, if you like, of monies to a company which is owned and or controlled by Mr. Barzani. The other company, which is in subparagraph B, is K Energy, which appears from documents produced or held by the Herbal Chamber of Commerce and Industry. And K Energy appears to be owned by Mr. Barzani together with the other original shareholders. And that company has received purchase orders of approximately $13 million during the same period. And Mr. Aziz exhibits the evidence for that and provides a spreadsheet of purchase orders, which he's compiled from data provided by Corec. There's another company called Ursal, which is dealt with at paragraph 69 of Mr. Aziz's statement. Now, Ursal is a peculiar company because it's owned in part by a cafe owner and dietitian, even though it's a company that was incorporated and has its trading activity as being more technical. Its licensed trading activity is to trade in antennae, solar energy systems, components and telecommunications equipment. So one would think that a company that has that aim and objective may not have a dietitian as a 50% shareholder. Of course, it could do. She could be a specialist in the company's activities. But the suspicion about that company, of course, is that some of the money that was paid to Ursal, which is what we would call an intermediary company, was paid to it prior to its incorporation. So again, that's other evidence that we found relating to the trading of Ursal.
Can I just stop you there, Mr. Lovett, because I see in paragraph 69, and the same thing appears in Mr. Bortman's witness statement, that it's suggested that the shares are held as nominee for the first defendant, for Mr. Rami. In fact, I think I'm right in saying that when you look at your pleadings in both actions, that allegation is actually missing. One's just left with left in the air, so to speak, with the oddity that there appears to be. Miss Natalie Attia appears to own these shares without it being actually suggested that there's a connection with one or other of the various directors. But what I think we're going to need to do when we get to the details of amendment is to look at the pleadings. There are one or two odd gaps like that that probably need to be filled in.
Yes, indeed, Roy. I've made a note of that, and I take that on board. Yes, and if we could look at that when I take you through to the certainly to the amendments and the pleadings in Mr. Rame's case. In relation, so Mr. Aziz, he talks about the Nokia and Huawei transactions, which are relatively recent transactions, which are again mentioned in Mr. Aziz's statement and Mr. Bortman's evidence. And then he comes on to talk about governance issues. That's at paragraph 83. And Mr. Aziz says that as a result of the refusal of Mr. Barzani to provide responses to legitimate questions that the IT directors have about the financial statements of Corec, Mr. Aziz says that the claimant has been unable to verify the accuracy of any of the draft monthly, quarterly, annual accounts provided by Corec, which have been characterized by very significant questionable payments to suppliers. And there is an independent report which I could take you to if you would like me to, but there is an independent report that's been prepared by a company called Compass Lexicon, which was the purpose of the report was really just to have a look at a high level at the limited information that has been provided to the directors, the nominated directors of IT, i.e. the 3 IT directors on the IH board. And the conclusion from the Compass Lexicon report is that further information is required, that there are some anomalies in the financial information. So there is an independent report that validates what Mr. Aziz says. But in Mr. Aziz's opinion, he as a director is unable to interrogate or analyze effectively the financial information or the limited financial information that he's been provided with. And his evidence is that he's made a number of requests for more detailed financial information, but those really have been met with a blank. And he says that that information has been deliberately withheld.
Yes.
And then the next point was the one which you referred to earlier, the shareholder loan claim. And again, this is important, like IBL, this is important purely and simply for the reason that this is a claim that IH had or ought to have run on its own. And if I could just take a step aside for a moment and bring you up to date, Your Honour, what has now happened is that, as you can see from both the pleadings and Mr. Aziz's statement, payments totaling approximately $75 million should have been made to the company as part of the original subscription arrangement, the transfer of payment in exchange for the shares in Corex. So IH should have received an injection of $75 million. It didn't receive that money, and ultimately IT initiated arbitration proceedings pursuant to a provision in the shareholders agreement which effectively gives certain rights to certain shareholders to bring an action against others where those others decline to do so. So in other words, it's a contractual derivative right, in effect, which is contained in the shareholders agreement.
Yeah.
So IH, so Mr. Aziz's evidence is that at paragraph 94 of his statement, he says, despite repeated requests by the claimant and me and the other claimant-appointed directors, the first defendant and Messrs. Jundi and Aqrawi have failed to take any action as directors of the company against CS in respect of the substantial sums owed by CS to the company. So that because of their refusal and therefore IH's paralysis and IH's inability to do anything about that, IT took it upon itself to bring this contractual claim, this derivative claim in arbitration.
Yes.
Now, I'm afraid to say, it's unclear in effect what the impact of the award or the effect of the award might be, but the arbitration went against IT. One would think that this was a fairly simple debt claim, but the arbitration went against IT on the basis that the claimants failed to discharge their Braganza duties when considering under the shareholders agreement whether or not to bring proceedings against the respondent CS and others, whether they exercised their Braganza duty to bring those proceedings. In other words, whether the bringing of proceedings was the only reasonable alternative that they had. And the arbitral tribunal, somewhat surprisingly by majority, found that the Braganza duty had not been complied with, and therefore the claim was dismissed. Now, the tribunal made a couple of findings in relation to a couple of elements of that 75 million loan, in relation to an alleged deferral of some of it, and then there was an estoppel in relation to another part of that loan. But a bulk of that loan, and I believe it equates to around $48 million, wasn't really dealt with in the arbitration agreement at all. And now IT finds itself in a somewhat invidious position that it's prevented from bringing any further claims. and those claims have been argued now that it's been argued that those claims may be statute barred. But of course, in relation to the current claims against the directors, we say, well, if they hadn't have refused to take those claims and they hadn't refused to try and reclaim the money on behalf of IH, then clearly not only would those claims be not be statute barred, but also those arguments that were raised late in the day about a breach of the Braganza duty wouldn't be relevant to a direct claim made by IH against its debtor. So again, it's a claim which we say is not a reflective claim of Correc. It's a good claim that IH could have made and should have made at the time. And now, of course, there may be difficulties in making that claim because of limitation periods.
Yes.
So that was the claim in relation to CS and IH. Now, Mr. Aziz's evidence is corroborated, and I think no, I'm still with Mr. Aziz. Sorry, just bear with me 1 second. I'm just trying to keep Mr. Aziz's statement open to save you having to leap through backwards and forwards between witness statements. So yes, so the other complaints that Mr. Aziz makes, that they are against Mr. Barzani from paragraph 96 to 99. He complains about the failure to appoint Mr. Froissart of Orange Telecom to the company's board. The background to that is that there was a resignation by one of the IT appointed directors, and it was believed it would be a fairly simple matter once that director had resigned to appoint his replacement. But that's been fraught with problems, and as Mr. Aziz says, that there's been effectively a refusal on the part of Mr. Barzani and the CS directors to ratify Mr. Froissart's appointment as a board member. And so that's another complaint that's made by Mr. Aziz. And then there's a final complaint, which I highlighted, I think, at the beginning. There's one self-dealing complaint made against Mr. Aqrawi, who's the first defendant in the director's claim. And that complaint is made at paragraph 100 of Mr. Aziz's witness statement.
Yeah.
And then there are there's some evidence Mr. Aziz gives about investigations into ongoing further suspicious transactions. And then I'd like to take you to the allegations and evidence against Mr. Rame, specifically dealt with in Mr. Aziz's statement.
Yeah.
So they start on page 104.
Yeah.
And they relate to a company called W, and that's at 104A, and then ZR Group, which is a very significant group owned by Mr. Rame, which appears to be a conduit for a lot of payments going out of Correc. And Mr. I will come on very briefly to Mr. Bortman's evidence, but he corroborates Mr. Aziz's evidence in relation to the activities and existence of ZR Group, W, which is at 104A, and then he also talks about Ursal, which clearly I need to address you on shortly. And then he also talks about the IBL kickback arrangements. Now, the allegations of corruption, although, again, they are touched on by Mr. Bortman in his evidence, but won't have escaped your attention, Your Honour. We haven't made those allegations against Mr. Rame directly, again, that is purely on the basis that we've had a lot of difficulty in serving Mr. Rame with the current proceedings, and if we keep updating proceedings as we go along and then try to serve, we will never get the show on the road, so to speak. So we've drawn a line under those corruption allegations, but needless to say, they do appear in other claims and in other arbitrations. It will not surprise you to learn. That's a summary. I can give. You've clearly been through Mr. Bortman's evidence. I could take you through his witness statement. A lot of Mr. Bortman's evidence relates to his discussions relating to the corruption element. And the detailed discussions that he's had with his witnesses. But that's the substantive part of Mr. Bortman's witness statement. But the remainder of it really does deal with the material that Mr. Aziz has talked about, which is, or the issues he's talked about relating to both Mr. Bazani's interests, but also specifically Mr. Rame's interests in these various companies that appear to be doing business with Corec.
Well, I don't think I need to be taken to it. I've read it. Unless you feel there's a need that I should look at anything in very specific, I've got the general gist of it.
Thank you, Ron. One of the reasons that I took you through that evidence is that clearly this application is it's an ex parte application, but it's been made on notice to IH. Now, for reasons best known to itself, IH has not appointed counsel and is not represented, although in other proceedings IH has been represented, but it's chosen not to be represented in this application. But I am just mindful of the fact that this is an ex parte application, and again, I'll come on to talk about the what one might otherwise call full and frank disclosure. I'm not entirely convinced that a full and frank disclosure applies to applications such as these, where the other party has been put on notice. But nevertheless, out of an abundance of caution, I did want to take you through some of the main parts of the evidence, given that there is no representative of IH, so to speak, who might want to put an alternative view. And in fact, you know, one of the issues that has previously come up when IH has been represented is to simply ask the question, even if IH did have representation, on what possible basis could it be reasonably submitted that it should not be making these claims or reserving its rights in relation to the making of these claims, which in our submission are viable claims against third parties. And I'll come on to make submissions on the losses and the reflective loss points. Can I turn now to the...
Let me say two things, Mr. Lovett. One, I think you should assume that you have a duty of full and frank disclosure and so on. But secondly, I have read everything you've asked me to read. So everything that's set out in your skeletons by way of disclosure of potential arguments, defences, and so on and so forth, or in the material that I've been asked to read, I have taken on board.
Thank you, Your Honour. If I could turn now to the test for the bringing of a derivative claim. Now, again, I could take you through the skeleton, which starts at paragraph 5.5, but I'm rather assuming that you're very familiar with the test and the exception to the rule in Foss and Harbart on the fraud on the minority. And as set out in our skeleton, we say that not only is the two-stage test satisfied, i.e. that there has been a fraud on the minority, both in the classic sense of a fraud, but also in the sense of perhaps the more watered down sense of an injustice that has been caused to the minority shareholders, which may not reach the threshold of a fraud claim. There is some authority on that, which again, I'm sure you're familiar with, but we say that we would absolutely qualify for the test, that limb of the test, as it applies to the bringing of a derivative claim. And I'm not sure whether you would like me to take you through that part of my skeleton.
No, I don't think I need to. It's I'm afraid one sees a lot of claims of this kind in arbitration and in the courts. And the reflective loss argument is one which appears with some regularity. So one sees quite a bit of this.
Yes. And perhaps then, Your Honour, that sort of neatly takes me to those potential counter arguments and the duty of full and frank disclosure. And of course, reflective loss was the first item that has been raised in the skeleton. And I think there are really two answers. One is that some of these claims are direct claims. There are two claims, the one that relates to IBL, and it's possible that some of the claims will have to be brought in arbitration, although there may be losses that a tribunal will find have been incurred or suffered as a result of the failure to bring a timely claim in relation to the IBL loan, which then could be visited at the door of the directors. So it's not necessarily the case that IH will bring those claims, but the substance of the claim against the directors is that they could have done something about it sooner. And that certainly applies. The direct losses to IH, and I don't think I have to make any further submissions on them because you've already taken them on board, is the IBL claim, and then there's the 75 million shareholders claim. Now, in relation to the in relation to other losses, there is you'll also be familiar, I'm sure, Your Honour, with the case of Giles and Rind, which purported to be a very narrow exception to the rule against reflective loss. And there's been a subsequent case in which is Garcia and Marex Financial, which is footnote 44 on page 21 of my skeleton, which suggests that the Giles and Rind decision should be narrowly confined. And there was a suggestion in Marex that it was possibly even wrong, but even if it subsists, it should be narrowly confined to situations where there is a legal impediment, where the wrongdoer is in charge of a company, and there's a legal impediment which stops a claim being made by the company, which would give rise potentially to an exception to the reflective loss argument. And we would say on the facts of this case, and particularly when one is dealing with an Iraqi company, where there may not be the remedies and claims that one may want to make, and particularly in circumstances where the person who is in effective charge of that company is blocking every opportunity and will likely block every opportunity of Correct to make claims, given that he is largely the beneficiary of a lot of those wrongdoings. There is, in my submission, an argument that the exception in Giles and Rind should be applicable in this case too. And that's something in my submission that in relation to reflective loss is a matter that should be dealt with by the trial judge, having regard to all matters, all the facts, all the evidence, and the evidence on causation and so on, and is not something that can be dealt with at a sort of a pre-claim stage, such as we are at the moment.
Well, there are 2 points. Two points arise there, I think, Mr. Lovett. The first is that I had understood at one point that the Marek's claim was going to the Supreme Court. Have I got that right?
Well, I'm not sure. It wouldn't surprise me, or I don't know. I can find out, but it wouldn't surprise me if it.
Well, I think it went to the Supreme Court and was heard last year, but then no decision has been reached. Now, there are two Marek's cases, I think, but one of them, which is very specifically in relation to this area, I think is probably still subject to determination by the Supreme Court, but it's worth checking that. The second point is this, that on the face of it, the question of legal impossibility to bring the claim, which is the Giles and Rind point as narrowed, so to speak, by Marek's. The question of legal impossibility is who is it that's being referred to here that is unable to bring the claim? And the relevant question, I think, will be, is this a claim that either IH could make, or more probably that Correct could make. And as you say, Correct is Iraqi, and any claim that Correct had to make against the various wrongdoers, including Mr. Barzani himself, would presumably be governed by Iraqi law. And the one thing that none of these cases have done is to examine how that works in relation to a foreign law. I've had cause to consider it in relation to the law of Russia, as it happens, elsewhere, where evidence was adduced that you could have double derivative claims in Russia, though quite how the system in Russia would cope with that remains uncertain. But this would be an area where one suspects there's room for a great deal of complexity.
Yes, indeed, Your Honour, and yes, and just taking the Giles and Rind exception, I think in that case the legal impossibility related just simply to an inability of the company to meet a requirement for security for costs, and of course, by extension, one could extend that principle, and it's sometimes difficult. I'm not sure I quite understand what the a legal impossibility always derives from a factual circumstance, and whether the legal impossibility in this case would be the practical impossibility of Correct ever recovering anything from Mr. Barzani, who is the sole statutory manager and shareholder. So as you say, I think there are a number of distinctions that can be made in this case, and then you have the added complexity of the cross-border element and the applicable law. but before I leave the reflective loss point, in my submission, there may also be an argument that reflective loss or the exceptions to the reflective loss principle are engaged anyway. And if I could take you to Giles and Rind, which is in the authorities bundle at tab number 14.
Sorry, bear with me a moment. My study at home is now as bad as my workplace, with boxes everywhere. Here we are. I've got it.
We'll do our best, Your Honour, to take them away from you when you finish with them.
That would be enormously helpful. Would be very much appreciated. My wife can hardly get through the door anymore, which she doesn't particularly want to do, I have to say. But anyway, there we are. Tab 14.
Any consolation, my home is exactly the same at this moment, Your Honour. So tab 14, internal page, and the case is 628. It's part of Lord Justice Waller's judgment.
Yes.
And I'm afraid the authorities bundle didn't actually have a copy of Johnson and Gore Wood. But what Lord Justice Waller does here is set out with approval Lord Bingham's summary of the authorities as they stood then in relation to reflective loss. And so within that judgment, he says these authorities support the following propositions. And then number one is the classic reflective loss, where the company suffers a loss caused by breach of duty owed to it. Only the company may suffer. And then further down the page, so after the citation of the authorities for that proposition, is sub number 2, where a company suffers loss but has no cause of action to sue to recover that loss, the shareholder in the company may sue in respect of it if the shareholder has a cause of action to do so, even though the loss is a diminution in the value of the shareholding. Now, in my submission, the COREC does not have a cause of action based on DIFC company law. Only IH has a cause of action based on DIFC company law. And subject to the discussion that we've had about the pleading points, it's clear that both in the case of the directors and Mr. Rame, that there have been breaches of DIFC companies law, which give rise to claims against them and causes of action against them. Now, in my submission, those causes of action are not open to COREC. It may well have a separate cause of action if it decides to exercise that right. But if you're with me on this, it does take these claims or these potential claims by IH outside the general prohibition on reflective loss, because the company does not have the same cause of action as the shareholder. The factual background may be the same, but the causes of action are different.
Well, that's not quite good enough, is it, on the current state of the law, as I understand it? You have to show both an independent cause of action and an independent loss. That's where the legal impossibility arises. If the company itself, which has been defrauded, is capable of taking action to deal with the defrauded question, whether or not the cause of action is the same as that which belongs to a shareholder, is neither here nor there. If the company can take action itself, then it's only if there's a legal impossibility about it taking that action that the shareholder himself can sue. Now, in the ordinary way, of course, the shareholder could sue by means of a derivative action in the name of the company. So the company would then sue if there was simply a practical impossibility about the company enforcing. And that's what I meant when I said at the outset, we could be talking about a double derivative claim here.
Yeah.
Now, the question which arises then, which is the difficult question and which is not canvassed in the evidence, and is whether as a matter of Iraqi law, Cooke could sue its statutory manager, or indeed Mr. Barzani in any other capacity in relation to all his elements of self-dealing and all the other losses which have flown to Cooke. But the whole point about reflective loss is that it bars the loss rather than barring the cause of action. There are certain types of loss that are irrecoverable in order to ensure that there's no double recovery and so on and so forth. Personally, I take the view that there's something faintly ridiculous about all this, and I rather hoped that the Supreme Court would grapple with it and say this is all a load of nonsense. As long as there's no double recovery, what does it matter? You know, the whole idea of reflective loss has got completely out of hand, I think. But it needs someone to grapple with this, which is why I say I think there are huge difficulties in it, particularly where you have foreign law concerned. And if it helps you, at this stage, I certainly wouldn't be saying, well, this is not a claim that is capable of being pursued because of the rule in Charles and Rhine. There's enough scope for argument here to think that this is a viable prima facie claim, which is all I have to decide. Is there a prima facie claim here that is capable of being pursued?
Yes, indeed, you're right. Thank you for that, and that really was my submission. That it is fraught with some complexity, and many of these cases are largely sort of turn on their own facts in many respects. And I think, for my part, and in my submission, I find it difficult to understand the distinction that was made, I think, by Lord Justice Chadwick in Giles and Rhind, and the narrowing of that rule in relation to a legal impossibility, because in practical terms, if you have a factual impossibility, then that is just as obstructive to the recovery of sums and damages. And one of the principal objectives, I think, that Lord Justice Chadwick identified is that one cannot have a situation where there is clearly wrongdoing, and yet those that have been harmed by the wrongdoing have no recourse against those who are responsible.
Well, indeed, that's got to be the basic question. Justice has to be done. The point which arises is whether or not you can have effectively, say, a double derivative claim. If Cooke is on its face unable to sue Mr. Barzani as a matter of practice, is there nonetheless the possibility that permission can be given for a claim to be brought by a shareholder in IH on behalf of Cooke? So that's, yes. There's the double derivative claim for you, and potentially that's an answer, so that there's no longer any legal impossibility in that sense. And that's certainly been the argument that has been put before me in other cases. But I say it's all fraught with difficulty as soon as you get into questions of foreign law.
Yes, I agree with you, Your Honour. And having given me that useful steer, perhaps I can just leave the reflective loss point in relation to both claims, both in relation to the directors and Mr. Rame at that.
Well, I'm happy you should do so, save that I think, for the reasons I gave at the outset, that one is going to need to particularize the losses that are claimed in order that they can be seen for what they are. In other words, what is the real loss here that's being suffered by international holdings, and what is loss that's suffered by Corec that is reflected in the loss in value of the shares of international holdings in Corec. And then one can examine each of the heads of claim, should it be necessary to do so, either because defendants appear who want to argue the point, or if they don't appear, the court itself can look at it and decide, well, what's the right thing to do? And the one thing that I think I have, and I may not have analysed the pleadings as closely as I might, but the thing that really matters to international holdings is the loss of its shares in Corec, having put all the money in. And that's really what it's about, isn't it? And that's a loss that, of course, is not suffered by Corec. That in itself is a direct loss. But I'm not sure that you've pleaded that, or at least if you have, it's not pleaded clearly. And that seems to me the fundamental point. Whereas all the self-dealing aspects by directors have caused loss to Corec, which at first blush is undoubtedly reflective loss in the value of the shareholding that international holdings has in Corec. But since you've lost the shares altogether, the one includes the greater includes the less, albeit that you've got all the causation problems on the loss of the shares by reason of the CMC decision and the like. But that's why I say to you, I think it becomes really quite important that you set out the particular losses that are caused by particular events or breaches, and primary cases and alternative cases and so on and so forth. Because at some point, assuming that I give permission, then the court is going to have to grapple with this, and it becomes vital that the case is clearly pleaded. So I'm afraid there's a bit more work to be done on that in all probability.
Yes, I hear you, Honor, and in fact, I think both of these cases, and we've been bedeviled with service issues, as you might imagine. But the cases were both originally filed, I think, before the Corec shares were taken away from IH, which is why it is perhaps otherwise surprising that you wouldn't see that is probably the main claim. But the tightrope that we're having to walk here is to initiate claims that have been, in the case of Mr. Rame, validly served on Mr. Rame, and can be amended if necessary at a later date if he makes an appearance, or amending those claims in a bit more detail now, and then having to reserve, which would be the devil's own job, because it's taken months and months to serve Mr. Rame. Now, of course, he's on notice that process can be served on him, and one wouldn't be surprised if he took steps to make service even more difficult in the future. I think we alluded to that in the skeleton. But that's the dilemma we face. And I wonder, and Your Honour, maybe I can address you and ask you this. If you are with me in relation to the permission and the amendments as they stand, are your observations on the relief claimed so fatal as to not to allow those amendments as interim amendments pending an appearance of Mr. Rame in his claim, if that makes sense?
And I understand exactly what you're saying. I have had a bit of a think about this, because I was aware that you wouldn't be able on the hoof to come up with particulars of loss. But I think we may need to spend a little bit of time looking at the detail. But all I will say at this stage is that a possible way of dealing with the point in order to ensure the progress of the claim is to give permission both to amend and for the derivative action, subject to a condition subsequent, which is that a schedule of particulars of loss and causation be provided in each action within a certain date, which would enable the case to make progress now, but within whatever period makes sense, for a thorough review to be taken to list the different heads of claim, some of which we've discussed and we can go on to discuss further, within, let's say, a period of 14 or 28 days thereafter.
I mean, that's no, thank you. I mean, that is something that we could certainly accommodate. Having ourselves identified the reflective loss points, we've already given some thought, I think, to the way in which we might articulate those claims further.
What I think it would do is this. I think if one went down that heading, that route of having a separate document that had particulars of loss and causation, one could get on with service of what there currently is. And it then becomes easier to deal with matters of particulars by way of alternative service or whatever.
Yes.
Quite. I mean, I haven't thought through all the details of this, but I think what I was perceiving as a possibility was that the orders for permission would be effective, so to speak, as at day one, but that if you then failed to serve particulars within whatever time was allowed, it would essentially be defeasible.
Yes.
The other way to do it would simply be to say that the order giving permission in each action would become effective upon the giving of particulars or the filing of such particulars with the court. I mean, I think I'm bound at the end of the day, if I allow the amendments, to give the third defendant who has been, what did you tell me at the outset? Has he been served? Or?
Mr. Rame has been served in both, with both claim forms, yes.
Yes, so he would have to have permission, it seems to me, to apply to set aside the amendments, though I'm bound to say I can't see what the possible basis would be for setting aside the amendments. You know, if you could apply to set aside the whole claim because it was all unfounded as a matter of reflective loss, that's a different thing. But the amendments themselves don't impact on the substance in any way, do they, really?
No, I don't think they do. I would agree with you, Your Honour.
It's development, it's updating its particulars and so on and so forth, but it doesn't change the basic nature of what's going on. So I can't see that there's any objection. He could have any objection to the amendments as such, but I think he's bound to be given the opportunity simply because he isn't present.
Yes, well, that I would, if you're minded to grant the orders, for the derivative claim and for the amendments, then clearly my preference would be that the orders, those orders would take effect subject to us not providing fuller, more detailed particulars within that a period of time, however one might like to frame it. But
yeah, okay.
clearly that our preference would be that the orders would be effective immediately and could be revoked or set aside if there was a failure to provide that further information.
Yeah.
Thank you.
I'm content to do that. That seems to me the right way to go, and I can spell it out in the order that's made.
Thank you, Your Honour. So that was reflective loss. There were a number of other heads, and that was probably, we put that one first because I guess to use a colloquialism, that was the elephant in the room. But there are other submissions which I've made in my skeleton in relation to what I would call full and frank disclosure. And I don't know whether you want me to take you through. We've touched on causation, but I don't know whether you want me to take you through those other elements which may be open to challenge by any one of the defendants.
Well, I think the most helpful thing, if you don't mind, Mr. Lovett, is to actually go through the heads of loss as they're pleaded. We've looked at them as they're expressed in Mr. Aziz's statement. But what I'd like to do really is to go through the heads of loss as they're pleaded, and for you just to tell me what your case essentially is in relation to each head at this stage. And it's that as further analysed and thought through by you, which would then form the particulars of loss and causation, which I have in mind.
Very happy to do that, Your Honour. Should we start then with, I mean, we're clearly not, the amendment application is only for the director's claim.
Yeah.
Which is at, in the main hearing bundle, I think it's C8.
Yes. Yes. I'm just going to read to you the note that I made when reading the papers in relation. This is CFI 13, the director's claim. You may just want to make a note of this, because that will help you when you come to think about the particulars. One, what loss is claimed and how do the breaches of the first to the third defendants cause them? Fundamental point. Two, if the loss of the investment of 810 million is claimed, is that the consequence of the Iraqi CMC decision? In other words, do you have to show that decision was corrupt in order to be able to get a claim off the ground at all, or can you claim it on some other basis, such as the failure of the directors to do what they ought to have done? Thirdly, if losses arise from self-interested dealing, is this an Article 54 case as such? The answer would be yes for the actual first to third defendant self-dealings, but on the face of it, no, so far as Mr. Bozani's self-dealing is concerned. Article 54 allowing the shareholder to take action in relation to the self-dealings of directors with subsidiaries of the company as well as the company itself. A slightly unusual feature and a very good feature, it seems to me, of Article 54 of the Companies Law. But Mr. Barzani's self-dealing doesn't fall into that Article 54 category on the immediate view of the wording as it stands, it seems to me.
No, sorry to interrupt you, but Mr. Barzani is not. He's not a defendant in these claims because his breaches are dealt with under the shareholders' agreement.
I've got that point, Mr. Lovett. Don't worry, I've got that. But the point is, if the claim then is framed as a breach of directors' duties in governance in failing to stop or failing to spot Mr. Barzani's self-dealing claims, or to pursue him in respect of such claims, does Article 54 apply?
Okay, I'm with you.
Right, that's the point. On the immediate view of the wording of Article 54, there's plainly a problem as to whether it covers that position or not. Self-evidently, the statute talks about setting aside the dealings. Well, you can't set aside the dealings without him being a party, of course. And you certainly can't get him to account for the benefit without him being a party. That, of course, can all be done in the context of your arbitrations and so on and so forth. But where you're looking at the breach of the other directors in failing to do something about it, whatever it may be, with resultant loss to Correc, can you get yourself within Section 54 or Article 54 or some other exception to the reflective loss rules, whether in Giles and Rind or anything else, which enables you to pursue the point in respect of the individual elements of self-dealing in which Barzani has been involved. And so that would hold true for all the heads of claim that relate to Barzani's misdoings. Now, if one then looks at the amended particulars of claim, this is where one needs to look at each head. So go to paragraph 28.
28.
The starting point, you see, inevitably, is that we're talking about the duties owed by Mr. Barzani to Correc and his breaches of those duties, which therefore give rise to losses suffered by Correc.
Correct.
Okay. It's in here whilst we're looking at that if you go to paragraph 53, we get the reference to Miss Natalie Attier, and there's a further name, isn't there? In fact, in the evidence, she's Natalie Attier something or other, isn't she?
Hamoud or something, yes.
Hamoud, yes. Okay, but anyway, you better get the name right. But also, there's nothing in paragraph 53 that links her in any way to Mr. Barzani or to Mr. Rame, whichever one it is who's said to be the actual shareholder for whom she's nominee.
Mr. Rame, I think she's a nominee for Mr. Rame, yes.
Yes, it's Portman 1, paragraph 97, and Aziz, paragraph 69. And that's the point that just needs to be tidied up.
Yeah, thank you, John. I have that.
Then another tidying up point, I think it's just a tidying up point, is if you go to paragraph 92, you've got Mr. Rame's self-dealing deleted, essentially, no doubt, because it's all in the other action.
Yes, correct.
And I suppose is the intention that the very last paragraph that you've left in 92, the last sub-paragraph, have you defined the self-dealing claim as being the other? Perhaps I've missed it. At all events, what you intend to do there is to cross-refer to the other action, isn't it? To CFI.
Yes, yeah.
I don't know if you've defined the self-dealing claim somewhere. If you have, I've missed it.
I thought it had been
Well,
defined.
it looks as though it should have been, doesn't it? Because otherwise, why would you have made the amendment?
And there's reference to it in paragraph 45 as well.
Right, okay. Well, perhaps you just need to check that. It's probable that I've missed it somewhere. Anyway, if you just go back to the structure of the pleading for the moment. So we go back to section C, paragraph 28, the duties owed by Mr. Barzani to Cooke and his breaches of those duties. And then you get duties owed as statutory manager of Cooke, the IBL loan. I'm looking just at the headings as one flips through. Engaging in competition with Cooke, undisclosed self-dealing Cooke suppliers, and then you get to governance questions, the refusal to appoint a CEO and a refusal to provide financial information, and then other breaches of duty on the part of Barzani at paragraph 63, which are all to do again with breaches of duty to IH in failing to do various things like convening general assemblies, preparing plans, and so on and so forth. So there's a distinction there between the duties that are actually owed to IH and the duties that are owed to Cooke. And that, again, I think is important, because when you come to reflective loss exceptions, it seems to me, on the basis of the authorities, one's always entitled to orders in relation to the governance of the company in question, in this case IH. You can get orders that require people to do various things in relation to it. Where you can't get damages in respect of the reflective loss suffered by its subsidiary. And I'm just think you need to try and work out which way you're going in relation to each of those, so a court can see where the duties are owed, what the losses are, and what the orders are that you actually seek by way of relief. If you go on then to D, you've got the duties owed by the first three defendants, and they, of course, are duties to IH. So there's your separate cause of action, and you plead Article 54 at paragraph 66, which has the magic words: a director of a company who has indirectly an interest in a transaction entered into by the company or by a subsidiary of the company, which gives you the statutory right against Mr. Barzani. In 54.4, you can get an order against such a person who fails to disclose the interest, setting aside the transaction and directing that he account to the company. But as I say, that doesn't quite cover the position on the face of it, of where what you're saying is that the other directors have failed to stop that director doing the various things to which Article 54 applies. Then if you go on to E, section E, paragraph 71, and facts giving rise to the breach of duty on the part of the first three defendants, paragraph 72 makes it tolerably clear that although you've pleaded separate breaches of duty, the breaches that are referred to are Mr. Barzani's breaches of duty to Cooke under Iraqi law, which the other directors have stopped him doing. And the wrongdoings have resulted in prejudice to IH as the owner of Cooke. And then you say, well, they warrant the removal of Mr. Barzani as a director of the company, which is IH, and that would be an order that you'd be entitled to get from the court to remove him as a director. That doesn't present any difficulties on the face of it, if you can justify it. But removal of statutory manager of Cooke, again, you may be able to get that, because we're not talking about damages suffered that give rise to reflective loss at all. Do you follow? There's a real difference. Real difference between what they talk about mandatory orders and specific performance. If you take the view that the underlying principle, the basic underlying principle of no recovery for reflective loss is to avoid double recovery and the problems that can arise as between creditors of the company and so on and so forth. If that's the basic problem, then you may be entitled to all sorts of other orders which don't give rise to that problem. And there's certainly suggestion in the cases that you might well be able to get an order that Mr. Barzani pays the money to Cooke. Do you see what I mean? But
yeah,
of course, that won't do you any good unless you make good your basic claim, which is for the return of the investment, or establishing that your claim to the shares in Cooke is perfectly good. When I say your claim, I mean IH's claim.
Yeah.
There are a number of different ways of putting the point, none of which are free from difficulty. But I think, as I say, needs to be set out. If you go on, then, the breach of duty on the part of the defence, I mean, it covers the same ground, doesn't it? Essentially, about the various things that he's done that are wrong. And then you've got some further breaches of duty directly involving the first three defendants at Section F. Failure to enforce the subscription agreement in paragraph 82. Failure to appoint Mr. Frassar. Well, none of those present problems on the face of it. Then G, self-dealing by the first and third defendants, paragraph 90. And that's just the first defendant, isn't it? Now, because the third defendant's going in the other action. And then at H, you have a summary of the first three defendants' breaches, and 96 is essentially the key to the Barzani problem. And then you jump straight into relief at Section J.
Yeah.
And what the basic point that I think is missing is what loss are you actually claiming? And there's a fundamental difference between saying we've been defrauded of our shareholding. IH have been defrauded of our shareholding in Cooke, which would require a whole bunch of different matters to be pleaded in the context of the CMC decision and corruption and everything else, which doesn't, to my mind at least, give rise to any argument about reflective loss at all. And all the individual points which go to the losses that are actually suffered by Coric because of everything Mr. Barzani has done, which do give rise to questions of reflective loss and whether you're entitled to bring the claim for the reasons I've already given. Thirdly, the direct claims that IH has under the subscription agreement and the IBL loan. And fourthly, all the other orders that you may or may not be seeking in relation to putting things right that don't amount to any issue of recovery of reflective loss on the part of IH for losses suffered by Coric. And those are the things that go to governance and any specific orders you want to claim in relation to governance. And as I say, it's not for me to plead your case, and it's not for me to teach, if you are my grandmother to suck eggs. But I do actually think that there is a deficiency in this pleading, because there are no particulars of loss and damage. And if you do plead the particulars of loss and damage, you've plainly got to plead how they're caused. And in doing that, you've got to bear in mind how the arguments on reflective loss may or may not run in relation to each of the different heads of loss and causation. So I'm not trying to be difficult, Mr. Lovett. Just trying to see the way through for the court's perspective.
So on the contrary, Your Honour, it's incredibly helpful. And I must say, I think some of these criticisms were raised. Certainly, the reflective loss point has been recognised. One of the, as I submitted earlier, one of the troublesome issues for us was trying to either make no amendments or very minor amendments to the claims. Clearly, we didn't do quite a good enough job. But in the back of my mind was this terrible trouble that we've had in serving those claims, which we talked about earlier in terms of a potential way around the amendments, because if the substance of the claims is there, they just need to be articulated in quite a bit more detail. But I think the substance of the allegations is I think reasonably clear, I would submit. But I do take your comments on board about loss and damage and the causation points, and we can certainly work on those to repair them.
Well, do you think, Mr. Lovett, that reading this pleading, the message would get across that what you're actually claiming is the value of the loss of IH's shareholding in Coric because you've been wrongly deprived of the shares in Coric?
Yes.
I think the answer to that's no. All of this is about the detail of the wrongs doing of subtracting money from Coric. It's not actually the loss of the Coric shareholding as such. And you know, where's the plea here of the CMC decision being utterly corrupt and so on and so forth?
Yes, and again, I think that can probably be partially explained, you know, by the sort of multiplicity of claims. I think it won't surprise you to learn that there is a investment treaty claim as well, but there is also a claim under the shareholders agreement, which certainly does raise the loss of the shares and the recovery of damages as a consequence of that corruption. One supposes that the question arising out of this is whether we wish to effectively consolidate our arguments and our claims into that arbitration, or whether we wish to pursue these claims as reformulated and as articulated by you earlier.
Exactly so. I understood that, and there's obviously a very big question for you, because I don't know enough about what's going on in the arbitrations as to what claims you pursue where and against whom. But if you are pursuing the directors, there are particular problems of the kind that we've already talked about in extenso ad nauseam in relation to effective loss. And you may be well able to overcome those. I don't know. But the question I think you need to decide is, are you going to make the fundamental point in this claim against those directors that, in fact, by reason of their failure, the correct shares have been lost? They should have stopped Mr. Barzani doing all the things he was doing and getting the decision out of the CMC that he did, and so on and so forth. I don't know whether that's the claim you want to put, but it isn't there for the moment.
But may I ask, Your Honour, if that's the nature of the claim that we may want to put, it's not in substance. Some of the other claims that we're making can certainly be better articulated as to whether they're reflective of Corex loss or direct losses to IH and so forth. But a claim for the loss of the shares is a substantially, well, it's an additional claim, but it's a substantial claim that would require that claim. I'm asking the question with respect. Would we need to? One would need to reserve that claim.
Well, that's why I wanted to take you through the pleading, because I think that is the case. If you are making a new claim, a different claim, and I can't see that claim is within the ambit of the present pleading, then I think you would need to reserve. I mean, it is a fundamental point. All the others are points of detail, aren't they?
Yes.
And therefore, there's a question which you may want to consider as to how far we go today. If you want to reframe the claim as including the claim for the loss of the value of the shareholding in Corec by reason of these defendants' failures to control Mr. Barzani or to do various other matters, then I think that needs to be expressly pleaded and set out in an amended point of claim that needs to be served. If you don't wish to do that and you're happy simply to pursue the other claims that are made for the same loss against other people elsewhere, then the point doesn't arise, and I think we can deal with all the other matters by the particulars of loss and damage that I've already mentioned as a condition subsequent, so to speak, to the granting of permission to amend and bring the derivative claim in its current form. So you may want to think about that.
Well, if I may, I'm not sure. I could probably say now, albeit without direct instructions, I think the preference would be to take the latter course and leave the claims for the loss of the shareholding in the arbitration claims, which clearly are going to be much easier to enforce in any event. And then if we make these same claims in the DIFC proceedings that are being made in arbitration, then again, one has a duplicity of proceedings, extra cost and expense, and so on. And then there's the enforcement issue. So my view is that we should amend the claims in the way that you have indicated that we should.
Yes, as I understand it, you wouldn't then be bringing a claim against these three directors in respect of the loss of the shareholding.
Correct.
Because they don't appear in the proceedings.
Correct.
Yeah, well, fine. That's absolutely fine. And in those circumstances, it may make sense in the particulars of loss and damage to make it plain what you aren't claiming. You see what I mean?
Yeah, the point is well taken, Your Honor.
Well, as I say, when I read these pleadings, I thought, well, the real loss here is surely the value of the shareholding, and indeed that's of course what the evidence goes to. But the evidence supports any number of different claims, so I can understand why it does that.
Yes, and as I submitted, the pleadings are very they're now becoming quite old, and I'm certain they predated the loss of the shareholding, as one could imagine from just reading them. Yes,
I understand this entirely. Now, just thinking, then looking briefly at the other pleading in 019, it doesn't give rise to quite the same sort of problems. Where are we? Tab 5, is it? Yeah.
tab 5, yes.
Yeah. Right. I'll tell you what my notes say here again. This appears on its face to be a derivative claim for losses suffered by Cooke in respect of self-dealings by Mr. Rami. That is all right by Article 54 of the Companies Act, but the question which then arises is the benefits obtained, who are they ordered to go to by the court? In other words, are they ordered to go to Cooke as the subsidiary, or are they ordered to go to IH? If you look again at the wording of Article 54, it's not entirely clear how that works, because it talks about the benefits obtained by the director in giving account to the company. And yes, in the earlier part of the article, it's talked about the company or the subsidiary. In the ordinary way, it would go to the subsidiary because that's where the loss has been suffered, and the company that owns the subsidiary would thus have the value of its own shareholding restored.
Yes.
The problem which arises in the present case is if life has moved on and you've got the whole problem of causation of loss of the shareholding. So it's just a point that arises again in relation to the particulars of loss and the form of the relief claimed.
Yes, I see that.
Do you see? I mean, you want to say that who's suffering the loss and who gets the relief? If you look at your page 19, C22 as it is in the bundle I'm looking at, we've got paragraph 60, for example. The fiduciary breaches his obligations of loyalty liable to counter his principal. Well, that's Cooke. And depending on what happens elsewhere, you may not want the money to go back to Cooke.
Yeah.
And so your relief sought question, declaration first offence in breach, no problem. Removal of first defendant, no problem. Declaration is a constructive trustee. For whom? IH or Cooke? And the last point I had was this, because of the various points that you've made about difficulties in service and so on, you've decided not to include any other of the extra newer matters in this claim against Mr. Rami.
Yes, Your Honour. The thinking behind that was that if Mr. Rami decides to make an appearance, we may then make an application to amend. But if he doesn't, we probably won't.
Okay. So again, my point here is simply that I think it would help to have particulars of causation and loss, and clarifying, in a sense, the relief that's sought, who's going to get the money, and so on and so forth. I'm not saying that, you know, there's anything wrong in the way you've pleaded the case, because you may want the money to go to Cooke, because if you succeed elsewhere, then you get back the shares in Cooke, perhaps. But on the other hand, if, you know, with these multiplicity of proceedings, you who quite knows how they'll work out and what you may want to claim and what alternatives you may want to pursue.
Yes, I take on board, Your Honour. Thank you very much. That's been incredibly helpful.
I'm not going to put you on the spot on this, because I appreciate it's all very difficult. But my inclination is to do what I indicated to you earlier, which is, unless there are further points that you need to make, which is to make an order giving the permissions you seek, but to give a sort of short ruling explaining why there's going to be a condition subsequent of serving particulars of causation and loss in each of the two actions.
That would be very helpful. You know, I would very much appreciate that. And I take on board the Article 54 points that you've made as well. Just in terms of logistics, and again, this is purely a Gibson Dunn issue. Do you have any view on timing? I was going to ask, and it may not be a long time, but I was going to ask for 6 weeks to produce the updated pleading with the amendment to the causation and the loss in both claims.
Well, I think in one sense, Mr. Lovett, it's probably up to you, because you're the claimant, and you know what you want to get on with and how this ties in with the other multiple proceedings that are going on. I don't think the court would necessarily have any difficulty with that. It seems quite a long time to me, but because you've got to tie it in with your other claims and make decisions, I can understand you may need that sort of time. I suppose the only point that arises, really, because this is where the impact on the defendants comes in, is what time is allowed to the third defendant to raise any objection to the amendments as they now stand, and what happens if and when the particulars of causation and loss are served.
Yeah.
I mean, I suppose the answer is it doesn't matter, because once you've served your particulars of causation and loss, if someone wants to take the point that the claim is untenable and wants to apply to strike out the whole claim, or wants to apply to strike out bits of it because they reflected loss, or for summary judgment in reverse, so to speak, then they're going to do that on that basis, aren't they?
Well, so we'll be in a different battleground altogether, I suspect.
Yes, but all I'm saying is the timing point doesn't matter in that context.
Yeah, no, I think that's probably right, Your Honour, yes.
So you can probably have as much time as you like, really.
Thank you. Well, maybe if we could do it within 6 weeks, 6 weeks being a backstop, clearly if we can do it before then, we will.
Yeah, okay. All right. Are there any other matters that you need to raise, or shall I make a ruling now?
I'd be grateful for a ruling. I don't think there's anything else to raise, Your Honour, that we haven't already touched upon.
Okay. Right. Well, the easiest thing, I think, is if I make an extemporary ruling now on both the applications. And then if there are points you need to raise at the end of it, you can do that.
Thank you very much, Your Honour. Thank you.
So first of all, I'm going to deal with the application for permission to amend the particulars of claim in CFI 013 of 2018. By an application notice issued on the 27th of April 2020, the claimants seek permission to file amended particulars of claim in the form enclosed with the application, and that there should be no order as to costs in relation to that application. I grant such permission and give my reasons for doing so shortly. First, the existing particulars of claim were served on the fourth defendant, which is the company on whose behalf the claimants wish to bring a derivative claim against the other defendants, which is the subject of an application which I have also to deal with. They were also served on the third defendant, Mr. Rame, in Lebanon, but difficulties have prevented service on the first and second defendants, who are resident in Erbil in Iraq, where current well-publicized problems exist, and there is inherent delay involved in service, combined with what appears to be an uncooperative attitude on the part of the authorities there. Secondly, the amendments essentially have the following impact. They take account of changes in the law of the DIFC since the claim was first issued in March 2018, and in particular the new 2018 Companies Law. They plead also developments since the original claim form in related proceedings in arbitration against Mr. Barzani, who is a director of the fourth defendant, like the first to third defendants, but against whom claims are progressed in an arbitration by reason of an arbitration clause in the shareholders' agreement to which he was a party. His alleged misdoings are one of the central planks of the claim against the first to third defendants, who as co-directors should have acted or caused the fourth defendant to act in such a way as to prevent him doing what he did, or in such a way as to make claims against him for what he did do. It's become necessary to update the existing particulars in respect to further matters disclosed since, or discovered since, I should say, in relation to the alleged breaches of duty on Mr. Barzani's part. A further effect is to delete the relief that had previously been sought by reference to appointment of a representative to carry out functions for the fourth defendant, somewhat akin to the appointment of a receiver, which had been sought in interlocutory applications. Thirdly, none of the defendants have filed acknowledgements of service as yet, or have taken any steps in the action, and there can be no prejudice to them in allowing the amendments to be made. Fourth, despite issues which appear to me to arise in relation to causation and the particular losses suffered as set out in the original form of the pleadings and repeated in the current proposed amendments, there is, in my judgment, no basis to say that the amendments themselves have no realistic prospects of success on the materials as they stand. It is hard to see, therefore, how there could be any objection to the amendments as formulated. Fifth, although the first to third defendants have not been served with the application, they are all on notice of it being made. There are inherent problems of the kind I have already mentioned in serving on the first and second defendants, and also problems in service on the third defendant, who is resident in Lebanon, where service is usually the subject of delay. I am content, therefore, to allow the amendments on an ex parte basis in these circumstances, but there must be liberty to the third defendant who has been served with the claim form to apply to set aside the order for permission. Who has been served with the original particulars of claim, to apply to set aside the order for permission within a given period of service of these amendments, and upon which I will hear counsel. My inclination would be to give liberty to apply within a period of 14 days of service. I should mention that the fourth defendant, being the company on whose behalf the derivative action is to be brought, if permission is given under RDC 20.65, it can itself have no objection to the amendments if such permission is given, and none if it is not. I therefore make no provision for any application on its behalf until I have determined the application under the rule in relation to bringing the derivative claim. There is one condition to the grant of the permission to amend. As I say, I can see no valid objection to the amendments themselves, but the overall shape of the pleadings in their agreed form does not particularize the losses claimed, nor how they are alleged to be caused by the breaches in question. Some of this may be obvious, but as a matter of inference, but it seems to me that is a fundamental principle of pleadings, that they should identify the breaches and the particular losses caused thereby. In the context of potential future arguments, whether or not the defendants choose to participate, the court needs to be clear about what is being claimed and on what basis, and about each of the heads of loss which is being pursued. This is of particular importance where issues of reflective loss potentially arise. Sorry, bear with me for a moment. In the present case, the claimants seek to bring derivative actions in the name of the fourth defendant so that losses directly suffered by the fourth defendant can be recovered. It is, however, clear from perusal of the original pleading and the pleading in its amended form that many of the losses claimed are losses suffered by Cooke, the subsidiary company of the fourth defendant. This potentially could give rise to the need for a double derivative claim, which might present some difficulty because Cooke is an Iraqi company, the shares in which, as a matter of Iraqi law, arguably belong to the original shareholders as at 13th March 2011, Mr. Barzani, Mr. Jorshin and Mr. Jixi, though there is plainly also an argument about a constructive trust should they be the legal owners of the shares. The statutory exception under Article 54 of the DIFC Companies Law, which enables a shareholder of a company to pursue a claim for the return of undisclosed benefits obtained by a director in a transaction with a subsidiary, as well as under a transaction with the company of which the shareholder is a member, on a claim by the fourth defendant as shareholder in Cooke, therefore, there is scope for recovery of sums obtained by the various defendants from what is described as their, quote, self-dealing, unquote. Whether that extends to cover a claim for a failure by directors to prevent another director's self-dealing must be an open question. Whilst there appear to be some claims which the fourth defendant can undoubtedly pursue against its directors for direct loss suffered by it in the shape of sums of money that the fourth defendant should have received under the subscription agreement from CS or in relation to the IBL loan, and remedies involving direct orders to do or not to do something may not infringe the rule against recovery of a reflective loss, to which there are undoubted exceptions. There is need for clarity in the pleadings so that the issues can be seen for what they are. Whilst dealing with this aspect, I mention also the need for clarity in the other action, CFI 019-2018, where the same point could arise to the extent that any claim does not involve self-dealing on the part of the first defendant in that action, Mr. Rami, who is the third defendant in these actions. There needs to be clarity in relation to the loss that is claimed, the relief that's claimed in relation to that loss, as well as the causation of the loss. The point, in fact, is of significance both in the context of permission to amend in this action, by which I mean CFI 013-2018, as well as in the context of permission to bring a derivative action in the name of and on behalf of the fourth defendant, which is the second defendant in CFI 019-2018. I therefore require a schedule of particulars of loss and causation to be provided in both actions as a condition subsequent of permission to amend and of permission to bring a derivative action should I otherwise be prepared to grant permission for the latter in either or both actions. I then turn to the application for permission to bring derivative claims in both the two actions. On that, my ruling is as follows. I'm satisfied that there is a good prima facie case against each of the first to third defendants in CFI 0132018 and against the second defendant in CFI 0192018. In each case, the action is for breach of duty to the company International Holdings Limited, the fourth defendant in the first action and the second defendant in the second action. I'm satisfied also that there is a good prima facie case to show that a fraud has been and is being perpetrated on the claimant as the minority 44% shareholder in International Holdings, the fourth and second defendant, respectively, in the two actions. I'm satisfied that there is a prima facie case that the first to third defendants are participating in that fraud, and that because they have either been appointed by the majority shareholder, CS, or are in league with its ultimate controller, Mr. Barzani, no claim will ever be brought against them or Mr. Barzani by International Holdings for breach of duty on their part, because they control International Holdings. The evidence appears in 2 witness statements from Mr. Aziz and 3 from Mr. Portman, and is compelling. The evidence of Aziz 1 and Portman 1 and 2 was before the court on an earlier application at which the fourth defendants, International Holdings, were then represented, controlled as it was by Mr. Barzani and the first to third defendants. The fourth defendants had the opportunity to put in evidence, which they notably failed to do. There is thus no evidence to challenge the evidence which has been put forward by the claimant. I am satisfied also that it's in the interests of International Holdings, as a defendant in each of the two actions, for such claims to be made on its behalf and in its name against the other defendants in each of the two actions. It is appropriate for the claimants to bring a derivative claim on behalf of International Holdings against them, as set out in the pleadings that are before the court. Any reasonable, independent and honest board of directors would do so. The terms of RDC 20.65 require the court to give its permission for the pursuit of any such derivative claim after the claim form has been issued. The application for such permission must be supported by evidence in accordance with RDC 20.66 and has to be served on the defendant 14 days before the application is heard, along with the claim form, the evidence and the application itself. It is clear to me that, as a matter of principle and proper construction of the rules, that the defendant referred to is the company on whose behalf the derivative claim is being brought, namely International Holdings. Service has been made on that company, and I am satisfied that the requirements of the rules have been met here. It's also right that International Holdings should indemnify the claimant against the costs incurred in bringing the claims. Each of the areas upon which I have expressed myself satisfied in relation to CFI 013-2018 is a fortiori the case in relation to CFI 019-2018 for the same reasons. And I'm prepared to grant permission for derivative claims to continue and for an order to be made in the form applied for in each action, subject to the conditions subsequent I have already mentioned when granting permission to amend in CFI 013-2018. That is the requirement that within a period of 6 weeks or less, full particulars of the losses claimed and their causation as a result of the breaches of duty pleaded, with the relief sought in consequence, should be provided. These particulars should have an eye on potential issues of reflective loss, where international holdings in each action is concerned, and where immediate loss appears to have been suffered by Cooke. For the sake of clarity, I confirm that the order giving the permissions sought in each action are effective as of today, subject to the filing of such particulars with the court within the period I have outlined, and the period for any objection to the amendments which is given to the third defendant in CFI 013218 runs from today's date. I hope that's sufficiently clear so that you know where you stand, Mr. Lovett.
Thank you very much, Your Honour. That's very helpful and much appreciated. There was one slight correction which I did want to make, which I think early in your extempore judgment you referred to the fact that the particulars of claim had been served on the third defendant, whereas it's only the claim form that has been served on the third defendant. But
yes, you're quite right. You told me that before.
That's fine, Your Honour. But that was the only point that I wanted to draw to your attention.
Thank you very much. I think also I may have referred to the second defendant in the second action when I meant to refer to the first defendant, but I think it'll be obvious when one looks at the transcript of the record to see what it is. But subject to that correction if needed, and the one that you have already mentioned in relation to service of the claim form and not the particulars of claim, the record sets out my reasons. All right, is there anything else that you want to deal with at this stage, Mr. Lovett?
I think that's all for the time being. Most grateful for your assistance, Your Honour, and thank you very much. That's everything from our side.
Right. And so far as the boxes of papers are concerned, how is that best dealt with?
Well, we'll liaise with the registry if that's acceptable. I mean, I suspect you've marked up some of those papers, which you would. I mean, when they're collected, I don't know whether you want just to indicate which ones should be destroyed. I mean, I was envisaging that they would be collected and taken back to Gibson Dunn's office. I wasn't quite sure what we'd do with them once we got them back, but clearly bundles or papers that you've marked up should be destroyed confidentially, unless you want them all to be destroyed. But certainly some of those evidential bundles could be reviewed if you haven't marked them. but I would leave that to you. But we'll be in touch through the DIFC court register, and we'll arrange a courier from our office in London to collect them.
Right. I think that would be helpful. What I may do is keep some of the files that that I've marked, though I have looked at this case before, haven't I? In the Court of Appeal, was it?
Yes, I believe it was. Yes, was that in the share? Was that the share pledge, the IBL action?
I can't quite remember. It's just that I think I've still got some papers in chambers left from this before. But what I'll do is I'll keep some of the files that I've marked up and made notes on. Probably only 2 or 3 that have the basics in them. And if you can make arrangements for your London office to collect the balance, that would certainly help me a lot. I'm not quite sure how long we're going to be continuing in lockdown for, but it would certainly help me to clear the stuff out of my room here at home if that's possible.
No, absolutely. I'm very happy to do that. And if it would help, I mean, if you wanted your marked up box to be couriered to chambers, if you want them completely out of the way, then that's an option as well. So we can take 1 box back to our office and 1 box to your chambers. But again, I'll leave that with you.
Well, you're not likely to want to put anything before me for several weeks at the very earliest, are you? By which time,
right.
Yeah, well, I might take you up on that offer, although I've got so many other boxes here that I've got to go back to chambers at some point on other matters. It's almost neither here nor there. But anyway, I'm very grateful to you for the offer. Thank you very much indeed.
No, not at all, Your Honour, and we'll arrange that through the DIFC registry. Right.
Now, I think probably the right thing to do, Mr. Lovett, if you don't mind, is if you leave the meeting, then I can have a word with the associate in DIFC, with Maita, and just make sure that everything's ironed out from the registrar's point of view. Does that make sense? Does that make sense? No. I'm asking the associate for her contribution. She's muted. Why is she muted? Can you unmute yourself?
Yes, I'm here, Sir Jeremy.
Very good. I'm glad you are. All right. I think it'd be just useful to have a quick chat when everybody else has left the meeting, if that's all right.
Yes, sure.
Thank you very much indeed.
Thank you, Your Honour. We'll leave now. Thank you so much. Thank you.
Very kind. Thank you. I'm not sure whether I pronounced your name right.
Yeah, it's Maitha.
Maitha, not Maita.
Yeah. Right. It's okay. It gets confusing.
I'm sorry. I should know that. You know, I've seen it in writing so many times, but never actually had to use it. Maita, right? All right. Well, you see that I've given permission, so that I made a ruling. The recording probably ought to be. The ruling probably ought to be typed up from the recording so I can approve it.
Okay.
I didn't ask them to submit an order, but perhaps you could ask them to submit an order in draft. Okay. And I can approve that as well, or you can draft it yourself, whichever you prefer.
Okay.
It's pretty straightforward. I mean, it's just taking the form of the draft orders that they've provided, but adding the condition that I've given and the opportunity to the third defendant to apply to set aside the amendments within a period of 14 days. Did I say 14? Yes, 14, yeah. Are you happy to do that?
Yeah, sure, it's fine. I have the recording, so I'll just listen to it again and type it out.
Thank you very much indeed. That's very kind. All right. Is there anything else you need to deal with from your perspective?
No, that's it, I believe. So yeah, so I'll type in the order and I'll send it back to you for your approval.
Thank you very much indeed. And is everything all right where you are? People are okay by and large?
Yeah. So actually, they've loosened up the restrictions now. So we're allowed to go out from 6 a.m. until 10 p.m. So that's good.
You can go out?
Yeah, from 6 a.m. until 10 p.m. After that, it's lockdown again. So it's good right now. But the number of cases are still high, so.
Yes.
Yeah.
Is that right? Yes.
Yeah.
Okay. And is there social distancing you're meant to keep?
Yeah, exactly. So
Yeah,
we're all like almost all of the entities are working from home, but like some of the malls are open, the grocery shops are open, stuff like that. But,
Oh, right.
but like to be honest, like all of the people are not going out anyways.
Right.
Yeah.
And how long are they saying they think this is going to go on in Dubai?
So it's still not confirmed, but from what we know, it's like until the end of Ramadan. So Ramadan is gonna end on the 23rd of May. After that, nothing is clear.
Yeah.
Yeah.
I think we're pretty much the same here. It's looking as though come the 1st of June, there may be a bit of relaxation. We've had a little bit of relaxation yesterday and this week. We're being told we can now go out and exercise as much as we like, just about.
That's good.
But and they've said that if you can't work at home and you are part of a manufacturing or industry or something of that kind, then you should go to work, but don't use public transport. But quite what that's going to result in, nobody seems to know. Anyway, we will see. But for most of us, we're going to continue to be working from home, certainly for the rest of the month, I think.
Yeah, same here, I think.
All right. Well, look after yourself.
Yeah.
Thank you very much indeed.
Stay safe.
And I will ring off at this end. Thank you.
Yeah. Okay. Thank you, Sir Jeremy. Bye
Thank you
bye.
for your help. Thanks.
Bye bye.
Bye then. Bye.